Today's guest is one of Sydney's leading family law and commercial litigation lawyers. With over 17 years of experience, John specialises in complex family law involving property, trust, business, and even international disputes. He is also a nationally accredited family law mediator and arbitrator, helping families resolve parenting and property issues efficiently and fairly. A seasoned trial advocate and a strong community supporter, John has also led charity initiatives benefiting Beyond Blue and Autism Awareness Australia. We're excited to have him share practical legal insights for everyday Australians navigating separations, property, family law matters. So for now, please welcome John Bui.
Thanks for having me.
Mate, thanks for coming in. Been in business for a long time. You said 12 years before. And You've been doing this for how long in total?
I've been in a law firm for 17 years, yeah.
And so your specialty is in?
Family law.
Family law?
Divorce, so property settlement, and then children disputes.
Yeah, nice. Yeah. And so when someone separates, what actually happens legally?
So separation is legally, it's about one party deciding that the relationship has irretrievably broken down. So you don't need to sign a certificate or anything like that, so long as either the husband or the wife or the de facto partner says, I think that we can't reconcile, that's separation.
Okay. And so what are the first few steps that they need to put in place together to kind of get the process started?
Maybe tell the other person. It's probably it's probably a good first step. Hey, I think that this relationship is over. And then, after that, it just depends on the circumstances and the dynamics, right? So, there's finances that we have to split. There's children that we have to decide where they're going to stay or how that's all going to pan out. Probably having a sit down and a discussion with your partner about how the future looks. You could also do your will at that point in time, like making sure that your testamentary wishes are properly determined, or you've made a proper determination in relation to your testamentary wishes. Does that answer your question?
Yeah. But in terms of, so let's say we've agreed, it's like, I don't think this is going to work between the two of us.
Yeah.
This is what we're going to do with the kids and everything goes smoothly. But what are the next steps? So do they call their lawyers? Is that the first thing? Is that the first action?
Yeah, definitely. I'd get advice very soon and very quick so that you kind of know where you're standing. Now, a big misconception is people think, okay, if I call a lawyer, I'm inflaming the situation. It doesn't have to be like that, right? It could be that you give me a buzz and you say, hey, John, I'm about to separate from my partner. I just want to know, what are my rights? There are a lot of misconceptions with property. Is it 50-50? The property's in my name, is it mine? Like these sort of misconceptions, the kind of things that people think out that's not true. Speak to a solicitor, know where you stand, know what your rights are, know what the possible outcomes are, so that when you're liaising or speaking with your ex-partner, you know your position.
What are some of examples that, like, it's just as a common generalized story that normally would happen in that scenario?
What do you mean by that?
So, like you said, know your rights, know what happens, but what are some typical things that normally you would advise in general?
Oh, in general?
Yeah.
Oh, okay. For an example, right, a matter I had yesterday, a client came and saw me and she said, I've got this property in Italy. It's in my name. My partner knows nothing about it. I'm not going to tell him anything about it, right? So that's a misconception that someone has about an asset that's in another country that potentially they might have had prior to the marriage. They don't realise that dealing with that asset or like selling it or transferring it to their brother or their mum or something like that can be seen by an Australian court as an attempt to dissipate an asset to prevent your partner from having a share of it. So, right. That's a scenario that kind of happens when someone calls me. I can run them through their misconceptions as to what they think is right and what the law actually says. That's one example. Did you want more?
Which kind of leads me to the next question. Like, what surprises people the most about how assets are treated?
Yeah, a couple of things I think I touched on already. One is a lot of people say, is it 50-50? That surprises people that it's not. The second is I had this property prior to my marriage, so therefore I get to quarantine it. It's mine, it's not theirs. That confuses people. Superannuation. A lot of people think that superannuation is untouchable. That's not true. Superannuation can be divided. The superannuation regulation laws allow us to divide superannuation so that we can split the benefits for the parties.
What does the law say when it comes to like the splitting of the assets? Like what do they look at?
Yeah.
To make it fair for both parties?
Yeah, so the court looks at, there's a case called Hickey and Hickey that the court follows a 4-step process. The first step that the court follows is assessing the balance sheet, right? So, what do we actually have? Yeah. And it's not about what you had pre-marriage. It's not what, there's no line at the time of separation. It's at the time that an agreement's reached or the court makes an order. That's the asset pool that we look at that time. So step 1 of the 4-step process is we look at what the balance sheet, what do we have to divide? What's in the asset pool? Then the second step we look at is something called contributions. So we look at direct financial contributions. That's actual money going into the relationship. So income, inheritance, compensation payments, lottery winnings, right? Then we look at indirect financial contributions. An example of that might be, say, you're a builder and you've built a house, but you've used your own labour to do that. So you didn't contribute finances, but you contributed, your efforts. That's an indirect financial contribution. The other thing that we look at is homemaker duties, such as cooking, cleaning, taking out the garbage, landscaping, that sort of stuff. And then we look at care of kids, right? So that's step 2, where we assess the parties' contributions. We look at all 4 factors and we say, what have each of the parties contributed? And then we determine, based on those factors, what we think the contribution-based entitlements are and what the percentage ought to be. So it doesn't necessarily mean 50-50. If one party came in with a lot of assets and it was a short relationship, the court's going to say, well, that's a significant financial contribution and they should get some credit for that during separation. So we might be 60-40 or 70-30 because of that large contribution that they had at the start of the relationship. Then we move over to step 3, and step 3 is looking at your future needs. So your future needs might be that, you've been at home taking care of kids, you've put your career on the back burner, your partner now earns a lot more than you do because, they've been working whilst you've been taking care of the home. And so you have an income gap. The court will say, well, it's not entirely fair that you've sacrificed in that sense, and the court will look at your future needs because of the income earning discrepancy between you and your ex, and the court might award you further percentage in your favour as a result of that. Also, future needs might be, if you've got any medical issues that prevents you from earning income, or you might be, reaching retirement age. Those sort of factors, the court will consider those factors to provide a further percentage in your way. So, for example, we go step 2, we say contribution-based entitlements, we say it's 60-40, and then we move over to future needs, and you might have the care of young kids, and so you might get some further percentage there. It might be 62%, 63% in total. Then the 4th step that we look at is what we call just and equitable. So the way I describe that is you run through step 1, you look at the balance sheet, you run through step 2, you look at, the contributions, and then you run through step 3, you look at future needs, and then you take a step back. You step back and you say, okay, now that I've done that and I've run it through this formula, what does it look like? Is it fair? Is it reasonable? So it gives the court...
Who determines that?
Well, I mean, some reasons why I think if you're going to find a lawyer, you should go to a lawyer that is a family lawyer, not a generalist lawyer, because that experience, helps to make that determination on what's just and equitable. Obviously, the end of the road is a judge decides it, or court of appeal judge decides it. And there's a plethora of case law out there that allows solicitors and judges to read to have that ideology or determination as to what's just and equitable and what's fair and reasonable in the circumstances.
So sorry, go back to step 4 you said?
So step 4 is it fair? We run through the formula, we run through step 1, balance sheet, step 2, contribution, step 3, future needs, and then we look at it all, we take a step back and we say, is that fair in the circumstances? So for example, like a situation where it might not be fair, it's a small asset pool. We've got $100,000 in equity. one partner has brought in a significant amount of cash into the relationship, but they're not the primary caregiver of the kids. They've got a short relationship. So you run through step 1, step 2, step 3, and you say, okay, I end up with, 80% to the parent that isn't the primary caregiver, and 20% to the parent that is the primary caregiver of the kids. But then you get to step 4 and you think, well, $20,000, is that enough to help, right? And so maybe then you change the percentage split to provide more to the primary caregiver of the kids because they need those funds in order to, care for the children.
Yeah, right.
Yeah.
Okay. And how long does all of that process normally takes as an average? I mean, I don't know if there is an average.
Yeah. Look, it depends. Obviously, it depends a lot on the parties' attitudes. I recommend everybody to get out of, litigation as quickly as possible. It's a reset button, for your lives. You don't want to be, in this kind of period of your life where you don't have any certainty of what the future looks like. It can be very stressful. A lot of my clients, once they sign on the dotted line, you just see that sigh of relief. And so, how long does it take? It can be very quick. Some people come to me with, a lot of discussion that's kind of happened in the family home. They've worked out amongst themselves what they both want, and then they come to me to make sure that it's fair and reasonable in the circumstances. And if I say, that sounds right, then, we can prepare the documents and it can be signed, sealed and delivered pretty quickly. Other times, both parties reasonable with each other, not trying to hide assets, want everybody to get a fair deal. They haven't made that they haven't had that discussion at home because they obviously don't know. They come to us, we give them an understanding of what we think is right. Their partner checks it with their lawyer. Everybody agrees. Then, you could get that done in 6 weeks, 8 weeks, maybe. And then other times it requires a little bit more. We might have to determine the balance sheet, like valuations, right? So, you're in property. What's the value of the house? I mean, that can be, not so contentious, but potentially you've got valuation of businesses, which, there might be a broader range. There might be valuations of overseas assets as well. And that might be adds a layer of complexity because we have to get a valuation from another country. So that stuff might drag it out a little bit. And then if we kind of can't get on the same page with, communication between the lawyers and, telephone calls with the solicitor on the other side, then potentially we can hire a mediator. So like a third party that comes in and mediates the dispute for everybody. And most cases settle at that stage. There are a fair few cases that settle, very early on, 4-6 weeks sort of a thing. There's a fair few cases that will settle at the, 8, 10, 12 week stage. And then the vast majority of the cases will settle at mediation.
And how long would that take to get to mediation?
Maybe 2 months. Yeah, 2 months, 3 months, so 8 to 12 weeks. Could be longer, could be shorter.
Right.
Depends on how quickly everybody is.
When is court unavoidable in the situation?
Family violence. If there's some serious family violence, if one party is not disclosing assets. So my client said to me, "Oh, it's in Italy. He'll never know about it." Well, obviously the advice I gave her was that it probably should be disclosed. When one party's kind of like put their head in the sand and they just don't want to deal with it, I've heard that you want to separate. I'm not ready to deal with that, but the other party wants to deal with it. So sometimes you have to involve the court just to get them going.
Right. And what's the financial difference between the two, mediation and court?
There's probably quite a significant difference. Court can be expensive. I think everybody's well aware of that. Mediation, takes it out of the court's hands, allows the parties to negotiate the dispute. They can be arranged. Court doesn't have to always be extremely expensive. If you need to go to court for a particular issue, then it can be confined to deal with that issue, and hopefully the costs don't,
So what are the costs involved in a court?
So you can run an interlocutory application, or you can run a final hearing. I'd say, let's say you had a dispute in relation to kids, and you were having a disagreement about how much time your partner should be spending with the children and how much time, you get to spend with the kids. Then we'd file an application, an initial application, an affidavit. You get yourself to court. You run an interim hearing before a judge. Something like that probably costs you 20 grand, 25,000. Yeah. Depending, but about there.
Yeah, fair enough. And so my next question is probably around the divorce itself. So, like, what's the one belief about divorce that is completely wrong?
Completely wrong. Yeah.
Maybe a general sense of people, you know, think about it in a certain way, but then with your expertise, with how many cases you see, it's actually not the case.
What's probably completely wrong is a lot of people think about their time with their children as their right. It's not their right. It's their obligation to care for their kids. And it's the child's right to know and be cared for by both their parents.
Yeah, wow. That's heavy.
Don't know if you post that one, but yeah.
Talk about cost, mistakes and costs and all of these things. So what mistakes cost people the most money?
I think hiding assets is a big one. I think that's, that a lot of people have these ideology that I'm going to hide my assets, or I'm going to, send the money somewhere, or, give it to my parents, or, create loan agreements and things like that. That's pretty costly mistake. Another costly mistake is not getting advice early. It's this real, if I call a lawyer, it means it's going to blow up. That's not true. Like, you call a lawyer to reduce the conflict so that when you go into, discussions with your partner, or your lawyer takes over and has those discussions for you, that you can get down to, what's fair and right and solve the problems quickly. Because you yourself might be emotional in it, right? You yourself haven't been trained as a lawyer. So what you think is right might not necessarily be. And so it's always good to speak to a solicitor very early on, reduce the conflict, try to, maintain as much of the family unit as you possibly can. Particularly if you have children, you're going to be in each other's lives pretty much forever. Get some advice so that, you're on the right page with what you're entitled to and what your next steps are.
Does any of this differ with, for example, like de facto, if you're living together but not married?
No, yeah. De facto relationships and marriages have the same rights as, these days.
So all of the processes, everything will need to be the same?
Yeah, pretty much the same. There's different sections of the Act, but and there's some nuances, but yeah, it's pretty much identical.
And so moving to, say, from a financial point of view, are prenups enforceable in Australia?
Yeah, they're definitely enforceable if they're done right.
I think first thing is, what is it?
Yeah.
And let's maybe explain.
Yeah, what a prenup is.
Yeah.
So prenup's an American word. We don't use, everybody knows what prenup means, so we use the word prenup. Prenup is entering into an agreement before the parties enter into a de facto relationship or a marriage, right? So, and it's basically an agreement that attempts to oust the jurisdiction of the court, which is to say that, we're going to sign this document, and if we separate, then this is how our assets are going to be divided, which hopefully prevents court intervention. The main benefit is, the main couple of benefits is you're entering into this agreement at a time where the both of you might not be emotionally charged about separation. The second really important point is that it can save you tens of thousands of dollars, right? Rather than going to solicitors and solicitors having to understand the factual matrix of the relationship and make a determination as to what's just and equitable in the circumstances. You've got a document there. So if you separate, and you say, hey, we've already done this, let's just go execute it and get it done.
What does it typically look like before?
Typically the way that people like to draft their binding financials agreements pre-marriage, pre-de facto relationship is what I got at the start of the relationship is mine, what you've got at the start of the relationship is yours, and then what we get together we divide as in accordance with the law.
Is there ever a case that it fails?
Yeah, definitely fails. It fails in times of if one party, if there's duress, if it wasn't properly executed, a party was coerced to do it, so duress. But that's probably the two main reasons when they don't work.
Would you recommend? Is there any particular people that you would recommend to have something like this for?
I think, look, in today's world, I know having a conversation with your partner before you're about to get married or about to enter into a de facto relationship and say, hey, let's enter into a prenuptial agreement is not the sexiest conversation to have. But I think everybody should get one. I think it's clear. It helps reduce conflict. It's a backup plan, really. You might never use it. Hopefully you don't. But if you need to, it's there. And I think it's a responsible thing to do. I read statistics all the time, and I don't know how true they are, but I think ChatGPT tells me that 40% of people are separating. So there's a high probability if you think about it, and because of such a high probability, it's probably quite a useful tool to use or to have in your arsenal.
Yeah, cool. This is not my world, so this is all new to me. And that's why I'm kind of like, wow, man, there's so many things that like, obviously a lot of our clients have gone through some of this stuff and is there anything that we could give advice in the sense of how do we get them to protect themselves given the situation?
Yeah. Look, okay, so, if they've got a prenuptial agreement, great. If they don't have a prenuptial agreement, then it's, I'm probably repeating myself here, but it's all about advice. Get advice, right? Yeah. But get advice not only from your lawyer, get advice from a team. Get advice from your accountant. Get advice from your financial planner. Get advice from your lawyer. Get everybody together as well. If
all the different professionals.
Yeah. If you don't have these relationships, of course, ask us. We can help. But yeah, everyone should be on the same page because whilst divorce is, can be a very stressful time in your life, it's also a reset button to, design this, the second part of your life. And you want to get that right, you want to get structures right. You want to get, where you want to live or where your kids go to school. You want to get your taxes correct. It's a time where you can restructure assets and maybe have structures that allow tax minimization and protection in the future. Your own property, it's time to look at different investment strategies. Now that me and my partner had this goal, this financial plan that we had together, or maybe you didn't have one, but now that you've divorced and your finances look different, maybe it's a time to have a look at your future plans, have a look at your investment strategies, have a look at your income and how you want your life to look like in 5 years. Yes, it can be a very sad time, but it's also a time for a rebirth.
Right. In our world, in the property world, I mean, obviously, like I said, tax minimization, wealth creation, retirement income is the big things that we talk about. Yeah. Structures is obviously a massive thing we talk about. So we talk about obviously SMSF, superannuation. We talk about having company structures, trust structures. Does any of that differ in any way when it comes to splitting assets and relationships?
There is a misconception that if you have a property in a discretionary trust that it automatically protects that property from the relationship. The courts don't look at that. The courts look at who has control. So if you ultimately control that asset that's in the discretionary trust, then the court may very well say, no, that's not a financial resource. That's an asset of the relationship. The court also looks at who receives the beneficial entitlement. So you've got a property, it's positively geared, you're getting $100,000 in rental income on a yearly basis because they've come to see you and you've set up the structure for them, and they're receiving that income on a year-to-year basis, and they're receiving that income in their personal name. The court's going to say, well, you've put it in the structure, but really you're getting the benefit of it. Mm-hmm. So really that becomes an asset of the relationship.
Yeah, you just keep going from the top all the way down to who ultimately benefits.
That's right. But that's not to say
this.
that it doesn't work. Obviously it does. In circumstances where you can prove that you don't have majority control, that there are a number and variety of beneficiaries that receive the benefit of the properties in the trust. So it works in scenarios where, say, you've got mum and dad as primary beneficiaries, and then the kids are adult kids, and there's assets in the in the trust, and there's a number of people that make decisions with how those assets are acquired, sold, dealt with, and then the beneficial entitlement is dispersed amongst a number of people. In a scenario like that, a court's more inclined to say, that doesn't look like you own that. That doesn't look like that's ultimately yours. That looks like a number of people are benefiting from this structure. So then the court will consider that a financial resource rather than an asset. So you'll look at what you receive out of that trust, like income, for example. And
your portion of it.
Yeah, your portion of it, and potentially will quarantine the asset. So if there's $10 million in that trust, the court won't add that to the balance sheet of the parties. It will say, well, okay, there's $10 million of assets in that trust, but you're getting $500,000 in income from it. And so I will look at that $500,000 in income when I determine the property altercation between the parties.
Yeah.
Yeah.
And what about a trust as a asset protection in general, not from divorces?
Yeah.
From
Well, in
outside?
general, yes, that's right. I think in like commercial, civil disputes, commercial disputes, yes, it definitely has much stronger weight there than it does in family law.
Yeah,
courts.
okay.
Yeah.
Yeah, fair enough.
Yeah.
Probably more about the parenting, man. Like, I'm very intrigued about that. So when children are involved, what does the court prioritize?
Best interest of the child, right? It's not about mum. It's not about dad. It's about what's in the best interest of the child. How do we make sure that this child is well looked after, has little impact as possible? And yeah, so a lot of times it's about coaching or advising your clients. Put yourself in your child's shoes, and what's good for them.
All right, so let's go to rapid fire. Let's keep it short and sharp.
Yeah.
One mistake you repeatedly see.
Hiding assets.
Really?
Yeah.
That's common?
All the time. All the time.
One thing business owners underestimate.
The disruption, the mental disruption to the business and to themselves. They underestimate that. John, it's okay. Let's litigate. I want to negotiate more. And they don't see the cost that it's causing them mentally.
Mm-hmm. One document every adult should have.
A will.
If someone feels uncertainty in their relationship, what's the first practical step?
Communication.
Wow. And something people should stop assuming immediately.
What's more common is potentially that the property is mine and I got it before marriage and therefore it's mine.
That's far out. That was so deep.
Deep?
Yeah.
I don't know how you're going to use that.
That was deep.
Yeah.
I think there's a lot of practical tools there that people can learn from. Unfortunately, these are the realities. And I think knowing and understanding and being aware, and it's a great first step, and listening and hearing from you on your experience and it kind of gives that different perspective. Like this is that you've been through over the years. It kind of gives that different perspective. Like, this is not my world. This is not what I normally see on a daily basis. So for me, this is all very, very new.
It's wild, isn't it? For like with like say like what you guys do, where it kind of like connect. Your find is, you separate, and then your finances are like all over the place, right? And a lot of times one party never had control of their finances as well. It would have been another party that has control, right? So it's really a time of, okay, well, I need to take control of this now, and now I need to structure it into the future. So we had a client the other day, separated. She's got one property that's in her name, principal place of residence, and then she's got another 3 properties that she's about to take on. So, we got everyone involved, accountants, financial planners, buyer's agents. and said, okay, well, she wants to set up her future now, and what does that look like? And so one of the strategies that the accountant came up with was putting the properties in a trust to benefit from, all the tax minimisation that can occur. We've got the mortgage broker involved as well, so that we can look at how we're going to do lending on that. Wild.
Cool, man. And so where would the audience be able to find you?
We've got a number of offices. We service Oran Park. Just opened that office up. Got a grand opening coming up very shortly. Canley Heights is where I grew up. So, Cabramatta, Fairfield was my stomping ground as a kid. So we've still got that office there, servicing the Canley Heights community, Cabramatta community. And we've got an office in the Sydney CBD.
Socials? And your socials?
John Bui, family lawyer, JB Solicitors. That's us.
Cool, man. Thanks for coming in.
I hope that wasn't too heavy for your
That was crazy.